Good morning, Deputy Judge President Ledwaba.
Good morning, Chief Justice.
How are you?
I'm soldiering on.
As all of us are. Sorry, I've just been informed that we're experiencing technical problems and to give our technical people a few minutes. Is it fine now? Oh, okay, thank you. Right. Sorry to keep you waiting, DJP. We're supposed to start at 9, but it's just one of those days. There's a lot of things going on that are pressing. Are you ready to start?
I'm ready, Chief Justice.
Okay. You hold a BProc degree from the University of Limpopo, obtained in 1984.
That's correct, Chief Justice.
It would have been TEFLOP then, not so?
That's correct, Chief Justice.
All right. You started your career in the Department of Justice in prosecution.
That's correct, Chief Justice.
How long did you remain in that position?
I was in that position for about 3 months.
And you decided that it wasn't for you and went to the sidebar?
Yes, I started my articles 3 months thereafter.
Okay. And you were with this firm of attorneys, Wyman and Partners, for 4 years?
That's correct, Chief Justice.
Before you started your own practice on your own account?
That's correct, Chief Justice.
Right. Okay. And you built that practice and left it as a director when you were appointed as a judge in 2005?
That's correct, Chief Justice. I was in that practice for about 19 years.
And you were appointed to the Gauteng division as a judge, that is, in 2005?
That's correct, Chief Justice.
And became the Deputy Judge President of the division in 2013?
That's correct, Chief Justice.
And that's the position you hold to date?
That's correct, Chief Justice.
Okay. You have acted in the senior courts, the Supreme Court of Appeal, the Constitutional Court. When were you at the Concord?
I was at the Concord in it was about 2019.
2019, for how many terms?
It was 2 terms.
2 terms.
Yes,
That's
the
the standard acting stint one is given there. You acted there for 2 terms. Did you get a chance to write judgments during that acting stint?
Yes, I did write some judgments.
How many?
I think I was a scribe in about 2 or 3 judgments.
Do you remember which ones they were? Or was it too long ago?
I remember that one of them had to deal with labor issues. The other 2 I cannot recall now, Chief Justice.
And when were you at the SCA?
I was at the SCA for 2 terms. It was during that period of COVID. I also enjoyed my stay at the SCA, Chief Justice.
Was it just 2 terms?
Yes, it was 2 terms, Chief Justice.
Oh, all right. And you did write judgments there as well?
That's correct, Chief Justice.
How many?
I think it could be a minimum of about 4 judgments, Chief Justice.
All right. And I would imagine that in your long career as a judge, you've written a number of judgments.
Yes.
Any of them reported? Those from the High Court?
Yeah, there are judgments that are reported. I can't
You can't
recall
remember,
I can't remember now.
the number.
I know some of them have been mentioned in the comments of other bodies, but I can't remember them now.
There's a lot you've done extrajudicially. As a practicing attorney, you were a member of NADER and until you became a judge.
That's correct, Chief Justice.
And you also held leadership positions in the Council of the Law Society and the Magistrates Commission.
That's correct, Chief Justice.
And as a judge, you became the chairperson of the Magistrates Commission.
That's correct, Chief Justice.
How long have you held that position?
I've held that position since 2019. It was for 5 years. After the expiration of the 5 years, the minister extended my position as the chairperson of the Magistrates Commission.
Right. You will be given an opportunity to tell us your vision for this division, what you intend doing with it, if anything at all. But before we get to that, I'm going to give an opportunity to our objections committee, which, as you are aware, has received objections to your candidature. I'm going to give one of the JSC's objections committee a chance just to pose those objections to you. All right.
Okay, Chief Justice, I may also take this opportunity to say good morning to other commissioners, minister, and other members who are here.
All right. Commissioner Ngqaito.
Thank you, Chief Justice. Good morning, DJP.
Good morning, Commissioner Ngqaito.
DJP, there are several objections to your candidature. There are 6. We've considered all of them. We have dismissed the objection relating to St. James de Chantal Home. You would remember that.
Yes.
We have dismissed the objection from Senior Magistrate Singh. You will remember that.
Yes, I've noted that.
Yes, but we could not dismiss the objection from the Helen Suzman Foundation and the objection from Mr. Pitso Ramatsebe. Now, to start with the one from the Helen Suzman Foundation, we've decided that you must answer it openly in this forum. Firstly, it relates to the fact that you were mentioned in the Madlanga Commission adversely. You remember what happened there?
Yes, I do remember what happened there.
Yes, maybe you should take us through from your perspective.
From my perspective, I can just mention that I heard for the first time in the media that there is a witness that alleges that there was money that was put aside in the amount of 2.5 M. That witness indicated that he was not sure whether the money was to be given to me or to the prosecutor. I also just want to mention that after that witness gave evidence at the Madlanga Commission, I was informed by the Chief Registrar that the Commission had requested a copy of the proceedings and a copy of my judgment. I can just mention in passing that before those documents were given to the Commission, I was not given an opportunity, or the Chief Registrar did not contact me to look as to whether there are any corrections that I needed to make on the proceedings. But I take that as being to my benefit because if that was done, other people could have thought that maybe I could have changed some of the things that happened on record. Immediately after listening to the evidence of witness A, I instructed an attorney to write to the commission and to check with the commission as to why didn't they give me an opportunity or warn me that there will be evidence that would be given against me. And in the response, the commission stated that they will be preparing a report to the president in December, and they'll deal with that matter. I also need to mention that I did inform the commission that if nominated, I intend applying for the position of the Judge President of the Gauteng Division. And the response of the commission was that they'll ensure that I'm not prejudiced in any manner, and they will ensure that my matter is dealt with before the JSC sitting. That has not been done. The commission has not yet come back to me. What I can say about the allegations that were made against me is that the witness A indicated that witness B will corroborate or would give more information about his evidence that I could be involved in arranging that bail should be granted for Mr. Molefe. The commission further indicated to me that the reason why they did not inform me about the evidence of the witness is that they only had that evidence for the first time when the witness was testifying. And when I was busy with my preparations, I asked myself that if that evidence was only given for the first time at the commission, how did it come that one of the commissioners should tell the witness to mention the name of the judge that was involved in that? That aspect is neither here nor there. I can also mention that I dealt with the bail application of one Mr. Molefe. It was opposed by the state. And when the proceedings started, the state advocate did not ask for my recusal. I'm mentioning this aspect that he did not ask for my recusal because the witness stated that they informed their seniors and their prosecutor about what they heard from their informers. The proceedings went on. I granted the appellant or applicant bail. And what is most interesting that I need to state to this commission is that about a month or 2 months after Mr. Molefe was granted bail, he was arrested, and 4 additional charges of murder were added to his charges. The magistrate refused bail, and the matter went to there was an appeal to the High Court. I need to mention that I did not take any part in appointing a judge who was to hear that matter. The matter was heard in the Johannesburg local division, and I think the retired DJP allocated the judge to hear the matter. And in that appeal, the court again granted Mr. Molefe bail in the amount of 400,000. In the media, what was mainly published was that I granted bail to Mr. Molefe, but when the other court granted him bail, they did not make news in the media. Again, the witness A also mentioned in the social media that he instructed the prosecutor to appeal against my decision. The prosecutor told him that there were no prospects of success. And that is where the matter is. What I can say is that when I dealt with that bail application, I dealt with it in the normal course of my duties. I also want to mention that it was not the first bail application that I dealt with as a DJP. And this incident happened during recess. Usually, if there are bail appeals or urgent matters to be attended to, I would go to my office and check, and if there are no judges, I'll deal with the matters. And when this bail of Mr. Molefe was entertained, it was not the only matter that was on the road. There was another bail application that I also entertained. Yeah, I think I can go up to that.
Yes, there are some further questions that arise from these objections, if you don't mind. The first one is whether you have answered directly that you took the money or did not take the money. I think we need to get that out of the way. The implication of the allegation is that Mr. Katiso Molefe made 2.5 million rands available for a payment of a range of people, which could include the police, the prosecutors, and even the judge. And the big elephant is whether or not the judge took bribe money. Can you just answer that?
I did not take any money in respect of this bail application. I did not know Mr. Molefe at all. I've never met him. I dealt with this matter in the ordinary course of my duties. And why I dealt with that matter, all bail appeals are regarded as urgent. Hence, I'm saying there were 2 bail applications that needed attention during recess, and there was no judge who was available that I could allocate these matters to. And it was not the first time that I would deal with the bail application of applicants. Mention was also made about me being involved in the bail application of Mr. Ntanzi, one of the accused in the Senzo Meyiwa case. Because there was no judge available and I realized that it is an urgent matter, I adjudicated on that matter and gave a ruling that Mr. Ntanzi should not be granted bail.
Yes, the second thing that arises is why, as the DJP, you did a bail, because ordinarily those things are done by, I would say, puny judges.
Commissioner, as a DJP, my job is not only just to allocate matters to judges. And I also do other work. I also do trials. I also sit in special motions. I also do bail application, so that I should be aware of what is happening in my court, so that when my judges complain that they are overloaded with work, I should have tasted, I should have done that work. Because usually we would sit with the judges and just for example, they'd complain that they are receiving about 40 unopposed applications, that number should be reduced. And if, as a DJP, you've been in those courts, you've seen those documents, you appreciate what your judges are saying. And even in my stint as a DJP, there's a time where I also did urgent court, just to have a good feeling of what is happening in the court that I'm a leader as a DJP.
The third question that arises out of this is that your judgment was a poor judgment. It did not engage with the correct principles because the nature of the offense placed the onus on the accused, and the reasons that you gave were poorly motivated. And this is being said in the context that this was an entire scheme arranged by Mr. Molefe to pay his way out of prison.
Commissioner, I deny that the judgment was a poor judgment. I gave reasons why I thought that there were exceptional circumstances justifying that bail should be granted. In some of the issues that I raised with the prosecutor considered that there were material misdirections on the part of the magistrate. I can think of one part in the judgment of the magistrate where the magistrate said, I'm not going to grant you bail because you cannot afford the amount of bail. And I also mentioned in my judgment that that was a misdirection because if an applicant wants bail, the relatives, other people can pay bail for him. The other misdirection that I mentioned in the judgment was that the magistrate said much as the applicant testified or made an affidavit that he had a house worth about 17 million, the applicant was supposed to have produced a title deed. And that evidence of the applicant that he's got a property worth about 17 or 14 million was not disputed. The other aspect that was raised by the magistrate that is in my judgment was that the applicant was supposed to have produced his salary advice showing how much money was he making a month. And that is an allegation that was not disputed by the state when this bail application was entertained. So I fail to understand on what basis is it alleged that my judgment was a poor judgment. And as I've mentioned earlier, that witness in particular told the prosecutor that they should appeal against the decision. There was no appeal. And I can also mention that when my other colleague gave bail to the same gentleman, as far as I know, there was no appeal lodged against the judgment of my other colleague. Yes.
The last question on this topic is from HSF, who say that your candidature should await the outcome of the Madlanga Commission. Any response?
Commissioner, my response to that is that this application is not about me. I'm looking at what is in the best interest of the Gauteng division. I think the division needs a leader. If the appointments are going to be stayed because there are other recommendations that needs to be made, I see this as not being in the best interest of the judiciary. I can also just mention that there have been many allegations made against judges, which have not yet been finalized, but some of those judges did apply and then they were appointed. Just to mention something again, it was in the media that there's a case, criminal case against myself, the DCJ, and Judge Ratamokwatle, CAS 130/2/2026, wherein one Mr. Tefo made an affidavit and alleged that the three of us have received an amount of 35 million. Now, if we are going to wait for this matter to be investigated before other important positions can be filled, I don't think it's in the best interest of the judiciary. I can also mention that there was summons issued against me for an amount of 50 million by one attorney, Mr. Tobani, alleging that by refusing to grant bail to Mr. Ntanzi, his client instructed him to withdraw as attorney of record And now he thinks that he's lost some income because of my decision. To sum it up, if there is an allegation against the judge, the Chief Justice and even the former Chief Justice has made it clear that if there is anything that needs to be made against the judge, it should be reported to the JSC. And these matters that I've mentioned have not been reported to the JSC. I can also just mention again that if one is faced with allegations of this nature which affect the judiciary, some of the decisions are not decisions that are easy to make. And whatever decision I make to apply and the decision to continue with my work and not taking special leave were based on, I consulted, I discussed the matter, some senior retired judges. If their names are requested, I'm willing to do that. But they also told me that before you take a decision to take special leave or before you decide whether you should step aside, in quotes, one should look at the seriousness of the said allegations against you. And in that discussion, they were also of the view that with what has been presented, the hearsay evidence of witness A, and what is published, the judiciary would be crippled if always there are allegations and that a judge should step aside.
Yes, so you're saying the allegations are serious, but there's no evidence to support them.
You know, the way they've been presented, I hesitate to say that they are serious because that is just pure hearsay. And if these allegations were serious, if we look at the evidence of witness A, he stated that he informed his superiors about this plan. And I think that there were other steps that they could have taken to ensure whether these allegations carry any weight or not.
Thank you. Then the last topic is the, it's the allocation of the case management responsibilities and trial responsibilities in the International Pentecostal Holiness Church case to Judge Portia Patlane, who has since been charged for corruption and bribery. The concern is that the judge seems to have had a prior existing relationship with the people that are alleged to have bribed her before she was allocated the case management and the trial duties. The question then that arises is, given that you are the person who did the case management allocation and the trial allocation, how did this happen? The suspicion being that she knew beforehand that she would be allocated this job, and that's why she started taking money from the alleged corruptors. Can you take us through from your perspective?
The practice in the Gauteng division in respect of case management is that the parties would request that I should allocate a matter for judicial case management. And I would look at the list of the judges, take into consideration if I have allocated them any commercial matters or not, if I've allocated them bail applications or not. And if I realize that the judge to whom I will allocate the matter for judicial case management is available, that matter would be allocated to the said judge. This matter was initially allocated to Judge Potterell. It was in 2020. He managed the matter. He dealt with other issues, like the parties wanted the matters to be consolidated. Actually, when I looked at this matter, there were three main cases. The other case involved money that was freezed, money of the church, and the Judge Potterill partly dealt with that aspect. And in 2022, according to the records that I have, the parties wrote to me. Usually when they write to me, they also copy their opponents, requesting a judicial case management. And I allocated this matter to Judge Pahlane. And the practice is also that if a matter has been allocated to a judge, that judge would not hear the trial because the judge has been involved in the matter, unless if both parties agree that the judge should deal with that matter. And as far as this matter is concerned, I think Judge Pahlane started managing this matter in about 2022. During the management proceedings, both parties agreed that she should continue with the trial. This issue that Judge Pahlane was not supposed to deal with the trial, in my view, there's no merit in it because the parties would have objected. This matter was set down for 3 weeks. And if there was anything untoward, that the judge should hear the matter, they could have raised it. Interestingly, on the first day of the hearing, there was an application brought for the recusal of Judge Pahlane. And that recusal application was based on the fact that there are allegations that she has been bribed. Judge Pahlane dealt with that application and dismissed it. And there was a second application for recusal. She also dealt with it and dismissed it. Judge Pahlane also alleges that she was threatened when she was dealing with this trial. She approached my office, told me about the threats against her, and I advised her to open a criminal case and to talk to the court manager so that an assessment could be made whether she was in danger or not. She further told me that the court manager did nothing about this, and she decided to organize her own private security. I can mention that I was concerned about the fact that a colleague is in danger and she's not assisted. She further told me that this matter was reported to Mr. Naidu at the Office of the Chief Justice to check if indeed she was in danger or not. Because it was disturbing that there would be private securities in the court building, armed. I raised this with her, but she continued to engage those private securities. So much as I've also raised other things, but there's nothing untoward that Judge Pahlane dealt with the trial because the parties did not object to it. Actually, the parties agreed that she should deal with the trial.
Thank you, TJP. So as I understand, you did not allocate her the trial. You allocated her the case management, and then the trial was as a consequence of an agreement with the parties.
Yes, I allocated case management, and while she was busy case managing this matter, they agreed that the duration would be about 15 days. Judge Pahlane informed my office and the office of the Judge President so that we could make, when we do the duty roster, we should know that she'll be doing that matter for 15 days.
But not for permission, just to inform you.
Yes.
Thank you. Thank you, Chief Justice.
Thank you very much, Commissioner Ngaitobi, and thank you, Deputy Judge President. Now that these introductory aspects are out of the way, I'm going to give you 10 minutes to tell us your plans for the division you seek to leave. All the questions that you have will be put to the candidate thereafter. But before you start, I'll get to you, Commissioner Malema. May I quickly formally welcome two newcomers to the proceedings. Deputy President Zondi, who represents President Mulemela from the Supreme Court of Appeal, and MEC Mamabolo, who represents the Gauteng Premier. Good morning, gentlemen, and welcome. You wanted to say something, Commissioner Malem?
No, I just wanted to follow up my good morning, CJ. I just
Morning.
wanted to follow up on, unless you're going to allow us later.
I did say that all the questions we have for the candidate will be asked after he gives us
Okay,
his vision.
thanks.
We have all morning for that.
Okay, thank you.
Are you ready, Deputy Judge President, to tell us what you see for the Gauteng division going forward?
Yes, I'm ready, CJ. I also think it would be in the interest of the public that I touch on the issue of the court order that was made against Mr. Paul O'Sullivan.
Oh, that is not an issue, though.
Okay.
That was clarified, and the Office of the Chief Justice had issued a statement explaining which judge had presided in that matter.
Okay.
So you don't have to worry about that. It's not
I'll
an
leave
issue for the
that.
JSC.
Yeah. Also, I also, in my preparation, wanted to make a comment about the sealing of envelopes. I don't know if the Chief Justice would allow me just to say something. President.
Is the CR17 sealed envelopes, you mean?
All right.
Okay. Let's hear the vision first.
Yeah.
Let's deal with the positive things. Then you can,
Chief Justice, one of my vision is that the Gauteng division is a division that is respected by members of the public. And I remember the DCJ saying that about 60% of the matters in the SCA come from the Gauteng division, which shows that we also creating work for the SCA. But it's important that this division should maintain the high standards, and the high standards and the high quality of judgments can only be made if appropriate judges are appointed in that court. So one of the things that I've introduced, that I've also learned when I was in the SCA, was that the president of the SCA would meet with what they used to call the top six, something like that. I've introduced a system wherein I meet with the top senior judges in Pretoria and Joburg to discuss the issue of appointment of acting judges. Because I've realized that some of the acting judges that are available is because maybe they could not be doing well in their practices. And we're also struggling to get senior advocates who could assist us with acting in the division. So one of my visions is to ensure that we train acting judges so that when they apply, we know that we've got competent and able judges in the division. Another important thing, one of my visions is that we all know that the Zondo Commission has made some recommendations, and there are also recommendations that would be made by the Madlanga Commission. It is important that when those matters are referred to court, the court should be ready to deal with them. And in dealing with those matters, we need well-trained judges. That is also my aim, that there should be proper training for those judges, and also that we need more courtrooms to deal with those matters. I've started with the process of checking as to where would we get more courtrooms. I've approached the Pretoria North Court, spoke to the court manager, and they've indicated that there will be 2 courtrooms that are available. I've approached the Palm Beach Court. The acting chief magistrate there also indicated that there are 2 courtrooms that would be made available so that we can deal with these matters involving commercial crimes. Why I think that it's important that we should deal with those matters is that in the training, in the symposium that I've attended, we were also informed that South Africa was previously grey-listed because there was no proper plan of dealing with these commercial crimes. And it would be in the interest of our country that we are ready for these matters, we deal with them effectively so that we should, our country should not be grey-listed, because there will be another evaluation that will take place next year. The other vision that I've got is we are in the process at the moment of memorialization of the Palace of Justice. There's a committee which is busy in making the Palace of Justice to be accessible to the people. And you'll recall that the Department of Arts have got recordings of the trial, the so-called Rivodia trial. So this is one aspect that I think is important, that the people should know what has happened, because also in the cell that the former president was held in, there are inscriptions of the Freedom Charter there. So it's one of my vision that one should pursue that so that the public should not lose this rich history about what happened in the Rivonia trial. And Chief Justice, also one of my visions is to ensure that collegiality among the judges is improved. In a division which has got about 80 judges, it's important that each and every issue that involves the judges needs to be dealt with effectively and properly, because these judges, at the end of the day, they'll be sitting together in deciding the matters that affect individuals and matters that involve issues relating to our country. Thank you.
Thank you, DJP. Do you want to touch upon the matter you mentioned earlier, the so-called CR17 sealed envelopes? Or have you abandoned that?
I can briefly just mention that I'm saying that because at the last interview, this issue was raised.
I thought I had raised the matter with you, and I thought we'd put it to bed. You gave your answer, and the transcript is here. Maybe you should wait to get a question.
Okay, I'll do that.
It's not an issue at the moment, as far as I'm concerned.
Okay. I'll not proceed further on that issue of the CR17.
Unless you're asked. Okay. Now I'll open the floor questions, and we'll follow the usual order. I've noted your hand, Commissioner Malema. We'll start with the representative of the division, Judge Davis. Go ahead, Judge.
Thank you, Chief Justice. I had 3 questions prepared, and I'll give a context for each one of them. Good morning, AJP.
Good morning.
You have greeted us, but we haven't all responded. Let me respond then. The first question is, the context is this. You have acted before as Judge President, but since the previous Judge President in the division has been elevated to Deputy Chief Justice, you've now acted constantly and for some time now as Judge President of the division. That's the context. The question is, having been there, and that's also why I ask, when one moves from a Deputy Judge President to the President of a division, the largest division in the country, when you move from managing one seat of the division to the whole division, how did you find that transformation? Was it easy? Was it comfortable? Was it difficult? Was it challenging? How did you find the transformation to be the leader of the division?
I found it very, very challenging, but I must just mention that with the assistance of other colleagues, it's manageable at the moment. I can also just mention that, we once had a diversity training where certain issues about the division were raised. And one of the issues that was raised was that Gauteng division being a large division, it's surprising that there are no women in the leadership of the division. And I can mention that it's also one of my visions that we should ensure that there is proper representation in the leadership of the division. Since I started acting as a JP, I've ensured that in particular women who've got the ambition of being in the leadership should be given an opportunity of acting. And I have requested the minister to appoint 4 women to act as DJPs. And also in my stint as an acting judge, I've appointed 2 men. And this issue of empowering women, it's something that I'm also passionate about. As the chairperson of the Magistrates Commission, I've looked at the stats when I joined the commission in 2019 and up to now. There are more women who are in the leadership, and I'll ensure that also the Gauteng division reflects that.
Thank you, AJP. My second question is the following. Commissioner Nkatobi has, on behalf of the Objections Committee, raised a number of objections, and in particular, the hearsay allegations made in the Madlanga Commission, and you've responded thereto factually, given the whole history of the bail appeal. Commissioner Nkatobi had also asked you directly whether you've received the money or the money mentioned therein, which you have denied. My question is a bit different. This bail appeal was heard during recess. Has anyone, for the purposes of that bail appeal, witness A, witness B, or any other person approached you at the time to ensure or to suggest or to in any other manner coerce that this bail application comes before you and that the decision goes a certain way? Was there any such approach? He's talked about the money, I'm talking about the approach and how this came before you.
There was no such an approach.
My third question then, if I give just a little bit of context, and I won't take much time. The Chief Justice has asked you about your vision for the division, and you've also, in response to Commissioner Nkatobi's question, said that the division needs a leader. You've mentioned your vision, mentioned a number of things. If appointed today, what steps do you envision or do you envisage that you can already implement immediately to realize that vision of yours for the division?
I've already started taking certain steps so that the division would be efficient. The division has been running very smooth under the leadership of the DCJ. And my main vision is that the bar should be raised. I don't want that the division now should be seen as a division which is not effective as it used to be, which deal with matters effectively as it used to be. You'll also recall that we had a challenge about matters being postponed to 2030. There are systems that have been put in place to ensure that justice is given to these people speedily. And I can also just mention that a request was made that we should have additional acting judges to assist with the crisis in which we are. And the minister heard our plea and agreed to give us 15 stipendiary acting judges so that we can deal with the workload. So it will just be a question of moving forward with what we've got and ensuring that the division runs smoother.
Thank you, AJP. Thank you, Chief Justice. Thank you, Commissioners.
Thank you, Judge Davis. MEC Mlambo, you have questions for the candidate?
Can I just make a remark? Yeah, thank you very much, Chief Justice. Let me take the opportunity to greet the Honorable Minister and all the commissioners, and good morning, Deputy Judge President.
Good morning.
Now, for me, Chief Justice, I've looked at the nominations and the support that were made, that are contained in the documentation made by various organizations, NADEL, the PLA, and then of course the rest of them that are here just to save time. And I think they've quite correctly and eloquently motivated for your support, and I would like to just say that that is sufficiently covered me as it relates to your suitability to hold the position and of course to perform the task, and thanks for the vision that you have shared with us for our province. Let me also say that I want to commend you for, in my view, for eloquently and very comprehensively responding to the matters that were almost carrying the potential to cast, doubt. I think you have cleared the air for me, and I also take the additional responses you gave to Judge Davis, so that for me, it's okay. I just wanted to say that, and of course, even on the statement you have made on the Matlanga Commission, in which you have stated on record your take on those issues. I think it's here, so that clarifies the issues. Otherwise, for me, I think I'm covered by what has been said, but I just wanted to wish you all the best. Thank you very much.
Thank you, MEC Mamabolo.
Commissioner Malema, followed by Minister.
Thank
Was
you
your
very
hand
much.
up, Commissioner Trolley? Okay, I've noted you.
Thanks very much, CJ. Good morning, Judge Ledwaba.
Good morning, Commissioner Malema.
Thanks for the clarity provided on the so-called allegations. So as we are sitting here, there is no any letter that says you must come and become a witness at Matlanga Commission.
That is so, Commissioner Malema. I can also just mention that when my attorneys wrote to the commission, we informed the commission that if they need a response, I'm more than willing to make an affidavit, much as all the issues relating to judges should be reported to the JSC, but we indicated the willingness to assist the commission as far as this issue is concerned.
Yes, so as you are sitting there, there is no letter that says you must appear before Matlanga Commission on such a date, or you must appear before a Judicial Conduct Committee on a date of so and so based on this allegation.
That is correct, Commissioner.
Now, the witness A if it's witness A, says he's got 12.5 million to be given to a judge and prosecutors. Has he made any effort to contact you to come and give you your portion of 12.5 million?
I've not been contacted because I don't deserve any portion of that.
Yes. So, but does he specifically say you or a certain portion must go to a judge?
The witness testified that he is not sure as to where would this money go. And as I've indicated, how my name came out in that commission is still a surprise for me.
Yes, so there was never an allegation that 12,000 will go to prosecutor, I mean, half of 12,000 will go to prosecutor Malema, and then the remaining portion will go to Judge Ledwaba.
There's no such an allegation, Commissioner.
I want to ask you about CR17 there because I'm conflicted. Thanks.
Minister.
Thank you very much, CJ. Good morning. Good morning, AJP.
Good morning, Minister.
Thank you very much for reflecting on a number of things. I think, firstly, I can confirm the work that is being done at the Magistrates Commission, because we've been able to see quite a number of magistrates, female magistrates that were being appointed just under my leadership since I've been here, and being able to close those vacancies. I think that can be acknowledged. My question goes to looking at your CV or the form. You've reflected having your involvement in the communities. One of the areas that you are reflecting is your involvement with Tsogofatso Special School, supporting learners with disabilities since 2019. Now, this year we celebrate 30 years of our constitution. And one of the issues we are saying that let's reflect in the journey that we've traveled. In your view, what needs to be done or how have we fared, especially in access to justice within the superior courts for people with special needs?
Minister, I think more still needs to be done. We are on track of ensuring that people with disabilities should also be considered in the higher posts. And I think I'm positive that would reach that stage where we are satisfied that everybody is well taken care of. If I understood your question correctly, that's my response, Minister.
Thank you very much. So your involvement with Tsogofatso, maybe if you can share with us.
My involvement with Tsogofatso is that when there were some needs, I assisted them financially, made some contributions so that they could cater for the needs of the institution.
Okay, thank you. My second question goes into issues of ethics. AJP, in 2025, there have been an unprecedented number of judicial misconduct cases that dominated the media headlines and society. And this speaks directly to what would say the issue of judicial integrity, but also issues of ethical standards and public trust. What do you think should be done to rebuild the trust in our communities about our judiciary? And also, how do you think we should be able to improve, or what can you do at the division if you are appointed, so that when people come to appear before our courts, especially superior courts where you would be the Judge President, and have confidence that there is ethics and things are happening correctly? What would you improve in that area, or what would you suggest, even for broader judiciary services.
Minister, the judiciary plays a very important role in our community. And immediately, if members of our public start losing confidence in the judiciary, I can say our country would be in a dilemma. So the other aspect that I would put in place, and it has always been in place, is to encourage members of the public that if they've got any issue with members of the judiciary, they should raise it with me or the other leaders of the court. Because if people are not given that opportunity to raise whatever issue that they want, they'll always have some doubts about whether the judiciary is doing a good job or not. So I would also encourage that members of the public, if they've got issues with the judges, that should be reported, and in other cases, they can be advised accordingly that formal complaints should be laid. And also, the other important thing is that if there's an issue that can be raised against one of the judges, is to ensure that the judge is invited, the issue is discussed, and if there is a complaint, to seek for information that would be supporting that complaint of the public.
Okay, I'm taking advantage. CJ didn't tell us the limits of the questions today.
It's a leadership position, so
Yes.
I think the standard is 3 questions.
Okay, the last one. Thank you, CJ. Last one from my side, AJP. You spoke about something that I'm quite involved in, and I'm glad to hear you reflecting. Perhaps maybe you can go better further on it. The issue of our country having been grey listed, and part of the issues that have been concerning many, or those that are evaluating us, is commercial, as you said, commercial crimes, but specifically terror financing, and the issue of our capacity as a country to have the skills that we need to be able to deal with it. You spoke about the issue, even linking it to also the issue of dealing with both the Zondo Commission recommendations in terms of prosecutions or court proceedings, and Madlanga Commission potentially coming and making space available. But beyond that, what else do you think we should be? Do you think that we've got enough judges with the right skills? That needs to be, especially looking at Gauteng, because majority of these cases are within this space, but also the time it takes for them to be concluded, because most of the outcome is looking not only at enrollment of these cases in courts, but successful prosecution.
Minister, I was fortunate about 3-4 weeks ago. We had a meeting in Zambia where we met with judges of other divisions to learn from them as to how are they dealing with commercial crimes. And I must say it was a very important and fruitful meeting that we had. And one of their suggestions was that in our system, we need to, or I've learned that in our system, we need to ensure that we have a continuous role with matters of this nature. We need to ensure that there is proper training for the judges who are dealing with those matters. At the moment, the regional court have got special courts dealing with these commercial crimes. But we think that it's important that the judges should also have some training. And one of the things that I raised was that these commercial crimes are very complex matters, which involves that one should have the knowledge of how the balance sheets are, of interpreting the books of the companies. And they should also, judges who are dealing with matters of this nature should also be encouraged to get assessors who should assist them. Like we are doing with at the tax court, the judge sitting in those courts will have assessors who've got the experience and knowledge about tax that would assist a judge to, at the end of the day, deliver a judgment that is well reasoned, which shows that all the issues are understood. So training is very important, and also proper judicial case management. One of the things that we also dealt with was that it's important that the prosecution should ensure that they investigate their case properly. And when a person is charged, the person should be given a copy of the docket so that there should not be unnecessary delay by applications for disclosure and so forth. And also a recommendation would be made that we need to look at the Criminal Procedure Act and make some changes, because when you look at matters of this nature, most of them are delayed by interlocutory applications that are brought. Applications for recusal, when the judge does not recuse himself or herself, this matter goes to the appeal. They go, when leave to appeal is refused, they go to the SCA. And I'm glad also to mention that I had a discussion with the president of the SCA and the deputy president that if we've got urgent matters which need to be adjudicated quickly in the SCA, like the petitions, it should be brought to their attention so that they deal with them quickly for their trial not to be delayed. Thank you.
Thank you. I'm done, Sir.
Thank you, Minister. Commissioner Trolik.
Thank you, Chief Justice. Good morning, AJP.
Good morning, Commissioner.
A while back, I read an article in a Sunday publication, and the heading was, "We need a reformed, revamped JSC to save us from judges behaving badly." In that article, the author says, despite all the travails we face when we've been able to rely on the judiciary as our safeguard, still is, but there are alarming signs. He goes on to say that in the past, we've had jurists of unimpeachable character, and so they should be. Then he mentions a number of unseemly matters involving judges, and the ministers referred to that too. And you yourself are not spared in this bail matter. So my first question is, as the only candidate for this position and the current acting JP, and the fact that you refuse to take special leave, should you not wait until your name is cleared in this matter, rather than present yourself while this cloud is hanging over you? Did you think about that?
I thought about it, and hence I said I consulted with senior judges, retired judges, on the facts presented, the hearsay evidence presented. It would not be in the interest of justice that the Gauteng division should not have a leader. There are cases that have been mentioned against judges, and looking at the facts of those cases, the information available, some of them are on special leave because of the seriousness thereof. But as far as this case or these allegations are made against me, looking at the fact that there is no appeal in the matter, looking at the fact that my other colleague dealt with a bail, and it's interesting that in the media, it's only my name that is mentioned. There has not been anything that I've heard from the public that the judges of the Gauteng division, they are involved in some shenanigans as far as the bills are concerned. So to answer you, Commissioner, on the information that is available, a hearsay, I don't think it's in the interest of justice that we should wait for the matter to be finalized. And again, as I've said, the commission made an undertaking that they will ensure that there's no prejudice to protect the integrity of the judiciary. They'll deal with this matter, and I haven't had anything from them on this issue against me.
Thank you, Chief Justice. The second question is, you told us that Judge Pahlane had an application to recuse herself and that she'd been bribed, and she dealt with that and dismissed it.
Yes.
You said she had a second recusal application that she dealt with and dismissed. You told us that she'd come to you and said that she'd been threatened, and you'd advised her to lay charges against the court with the court manager, and that apparently nothing happened, and that she'd also reported to Mr. Naidu from the Chief Justice's office to no avail. You then said she arranged private security and that there were private security guards in court that were armed. You then allocated her to case management, not to preside over the matter, the trial. But then you informed us that Judge Pahlane advised you that she would be dealing with the trial, not requesting permission or allocation. Now, against that background of the recusal applications, this private security in court, the fact that she'd laid complaints and nothing had happened, did you not think that maybe she was not the right person to be presiding over that trial and allocate somebody else against that background?
My response is this. I remember when this issue surfaced, I had a meeting with Judge Pahlane and the DCJ about this issue of recusal. By then, she had not yet made a decision as to whether she's going to recuse herself or not. And we told her that we are waiting for the judgment, and we could not tell her which way she should go. And in that meeting again, because the parties agreed that she can deal with the matter, it did not cross my mind that I should tell her not to continue with the case.
Thank you. And my last question is, you mentioned it and the Chief Justice said that it had been responded to, but I'd like to hear your response around the special 48-hour dispensation that was granted to Mr. O'Sullivan.
Commissioner, I was not involved in that matter. It's unfortunate that when that order was mentioned, my name was raised and said I made that order. There's a media statement that has been made to clarify that I was not involved in that order. That order was made by another judge. So, as to why the judge made that order, it is done, and I cannot reverse that. But this also shows that we need to be very careful that our judiciary should not be unnecessarily tarnished. Because some of the things, if media statements are not made, what will hang in the heads of the people is that Ledwaba gave Mr. O'Sullivan a special dispensation that before he's arrested, he should be given notice. I was not involved in that matter at all. And the name of the judge that was involved has been made public.
A follow-up question, is it a judge in your division?
Yes, was acting in my division, the judge.
And what has been done about that judgment?
The judgment was made in 2019. That order was made in 2019, and nobody challenged that order. So there's nothing that I can do. The order is there, it's valid until it is challenged.
Thank you, CJ.
Are there follow-up questions? Okay, noted. Commissioner Gottsel?
Thank you, Chief Justice, and good morning, Judge.
Good morning, Commissioner.
I just wanted to ask you about, I just wanted to ask you about the notion that generally the court rolls in the Gauteng division have been severely backlogged and that there's been some administration issues. But recently I heard that there's been a significant improvement and whether you could shed some light on that.
We have a challenge. Let me not say we had a challenge. We have a challenge with matters involving the Road Accident Fund. Those matters, they form about 80% of the matters which are on our roll, and they also affect other matters, and hence the matters were postponed to 2030, 2031. The leadership of the division met and realized that it would benefit the division if matters are mediated before they are allocated a trial date. Why I'm saying this is also that you'd find that we've got a roll of about 50 matters on the roll. And some of those matters are settled on the day of the hearing. And that would cause unnecessary costs to be paid by the RAF. But with the system that has been introduced, we think we are going somewhere. Most of the matters are settled earlier. And at the moment when one applies for a trial date after the matter has been mediated, the date of hearing is allocated within 6 months.
Okay. And then I understand also that acting judges often are appointed. There are several of them to help keep the administration going. But in your view, could you just, well, firstly, perhaps explain how many judges there are in this division and what, in your view, should be the required or a proper amount of judges to keep up with the growing number of matters on the roll?
Commissioner, we've got about 80 judges. And yesterday I read in the media that they've taken 2 of my judges who would be going to the SCA. The report, the so-called Moseneke report, clearly stated that there need to be more judges appointed to assist with the workload. And I've also mentioned that I also want to thank the minister that he allowed the division to have additional 15 acting judges on stipendiary basis to assist us with the workload. So there is a need, and even it's mentioned in the report that more judges are needed. But those judges, as I've said earlier, it should not just be a question of appointing them as judges. We need to ensure that we get judges who can be able to deal with the complex matters in our division and to deal effectively with the workload that we've got.
Thank you, Judge. Thank you, CJ.
Commissioner Breitenbach?
Thank you, Chief Justice. Good morning, Judge.
Good morning, Commissioner.
As chairperson of the Magistrates Commission, the position there has been the same system which adopted more than 30 years ago to fill positions for district level magistrates by advertising only once a year, despite the total number of positions increasing by 1/3. It is clearly no longer fit for purpose. We see anything between 150 and 300 positions advertised once a year, and then it takes around a year to 15 months to fill those appointments. What did you do as the chairperson to modernize and update this very outdated system?
In improving the system, Commissioner, we are in the process of ensuring that the applications are completed electronically, because we find many applications and there should be shortlisting and so forth. That also is something that takes time for the positions to be filled. But we are in the process of ensuring that we advertise twice a year to ensure that we've got enough magistrates to sit in our magistrates' court.
Thank you. You replied to a previous question that you'd been abroad to gather information on, more particularly commercial crime prosecution, and that you'd learned there that a running role, proper training for presiding officers, assessors, proper disclosure and trial readiness were important issues. Is that correct?
That's correct, Commissioner.
But you'll agree with me, Judge, that those are issues that we all know, and you must have known them before you went there. The specialized commercial crime courts were established more than 20 years ago, and those are principles that have been entrenched there. That's nothing new. The fact that it's not enforced is a different issue altogether. Those are not new principles. What is an issue with commercial crime, you will agree with me, is the Stalingrad tactics employed by the defense. And I would like your views on what the judiciary should be doing to limit the success of those tactics.
Limiting those tactics, I think a proper judicial management can assist. And I also think that there should be proper investigation of the matters. The other reason that prolong this case is unnecessary is that you find that the prosecution would charge the accused with about 50 charges, and they would put about 20 accused to be charged at the same time. Those are some of the causes of the delay, because if you put 20 counts against the people, and there are 20 accused, by way of example, should one of the accused maybe not be ready to come to court on a particular day, those matters are postponed. But I think if there can be a system in terms whereof the prosecution would put their best cases and try to limit the number of the accused, that can have a positive impact on how these matters are dealt with.
If I may, Chief Justice, but from your lips, Judge, to God's ears, but I'm going to leave it there, but in my view, you haven't satisfactorily, for me in any event, dealt with the Stalingrad tactics of the defense. All you've done is discuss shortcomings in the prosecution. Thank you.
Thank you, Commissioner.
Sorry, Chief Justice, I want to just follow up.
Yeah.
What did Commissioner Breitenbach say the judge had not satisfactorily answered?
How to deal with the Stalingrad tactics of the defense.
How should the judges deal with Stalingrad?
Do you expect Commissioner Breitenbach to?
No, I mean, I would.
I think you should direct that question.
Yes, not her, but
you can't
to
cross-examine.
yes, not to Commissioner Breitenbach. But she says, DJP, that you are not answering how judges should deal with Stalingrad. And as someone who's been on the opposite side of Stalingrad, I can ask you to outline for us. It's a real problem that Commissioner Breitenbach is raising across the board. But we say, well, the judges are allowing Stalingrad because they easily give postponements, easily give leave to appeals. do not impose enough cost orders, etc. But can you just help us on that and answer the question directly? Do the judges have the power, and what are the strategies available to deal with Stalingrad?
As I've mentioned, proper judicial case management can assist in the sense that before the trial commences, you check with the parties if there's been disclosure, you check with the parties if there are any admissions that can be made, and also the other tactic that is used is this application for recusal of judges. There are decisions which stated that applications of that nature are not appealable unless in very exceptional cases. But judges need to be aware of such cases that in matters of that nature, if interlocutory applications are brought where there is no merit in them, the practitioners should be told that this is how this matter is going to be dealt with, and also to state that some of the issues that are raised, I think the judges should be bold enough to tell them that the trial should proceed, and whatever interlocutory application that you are raising will be dealt with after the trial shall have been finalized. So it's more also a question of training and ensuring that judges play the important role in matters of this nature, because there are in certain instances where you find that the prosecution and the defense come to court and say, we have agreed that the matter should be postponed, and the judge does not make an inquiry as to exactly what are the reasons for postponing. So I think judges should play a more active role in matters of this nature so that they should proceed and reach finality. Thank you.
Sorry, Chief Justice. I mean, what about the actual strategies? So I can give you an example. If you can see that the advocate is playing for time, why should you not make an appropriate cost order or refer them to the professional body? Because Stalingrad is a form of abuse.
Commissioner, at our meeting, we also looked at this issue of making an appropriate cost order, which I think would be an effective tool. When we discussed the question of referring the matter to the professional bodies, in our discussions, we were of the view that this may prolong the matter unnecessarily. But on the issue of issuing an appropriate cost order, we think it is an effective tool that can be used so that when practitioners have some delaying tactics, they should know that at the end of the day, it may hit their pocket.
Yes, I think we can now give you 10 out of 10, Commissioner Breitenbach.
Hi. Commissioner Ngunyan.
Thank you. Good morning, DJP.
Good morning, Commissioner.
Arising from your presentation and response from my colleagues about your vision of this very important division of High Court of South Africa, I've got two questions for you, just for clarity. One, you have been the DJP for quite some time, and obviously you are aware that this division has produced legal practitioners from pupillage, from legal practitioners, some are silk, and some, of course, have elevated to the benches and have written good judgments. And you've just told us that some from this division have been elevated to Supreme Court of appeal, for instance, and your predecessor in office has been elevated by us to be Deputy Chief Justice, which speak volume of the importance of this division. You also know that this division is one of the divisions that has been very good in the transformation agenda of the judiciary. Now, I didn't hear you clearly whether you are going to pursue that praiseworthy work that you and your predecessor in office have been doing in this province. Can I hear you more on this?
If I understand the question correctly, I've indicated that one of my visions is to ensure that the bar is raised. And in a division that has got so many judges, interacting with the judges, it's a good tool to make. Last year, usually would have the meeting of the judges in Pretoria separate and in Joburg separate. But now in improving collegiality with the other judges, at the meeting we agreed that at least once a year, all the judges of the divisions need to meet and then discuss the issues facing the division. And we had a very successful meeting. So having an open door policy, improving collegiality of the colleagues, I think it's something that can assist that the division always performs better.
Thank you. The second one, Gauteng as a province is economic hub of the entire country. And however, there has been some worrying, shall I say, perceptions. You will recall the then Premier Monkonyane launching a campaign she called Wanyatsotsi. And responding to this perception that Gauteng, some others would dub it as gangsters' paradise. The emergence of, or rather the revelations, which we have already alluded to from Madlanga Commission, as well as what is alleged to have been happening in one of your important metropolitan municipalities here, gruelling, for instance, around corrupt activities and the issue of police themselves in the province being having some hand in the cookie jar, as it were. Now, in your vision, are you going to be able to lead a campaign to cleanse this image through as the head of the judiciary, if you are appointed? Can you assure us that you will be the leader in that campaign? Through, of course, judiciary, so that everyone would know that the judiciary is going to deal decisively with the people that are actually tainting the image of this very important province of ours. Thank you.
Commissioner, the judiciary should ensure that the matters that are coming to court are dealt with speedily, effectively, and if people have been found guilty, appropriate sentences are imposed. We cannot, as judges, say that if a commercial crime matter would be before us, we want to show them that we are going to convict, because it will depend on the evidence that would have been presented. So it will also be important that there should be proper investigation, and the judiciary should play an important role of ensuring that those matters are heard, a continuous role, and not to allow the practitioners to use some delaying tactics when matters of this nature are before the court. Thank you.
Thank you, CJ.
Commissioner Mwimanga?
Thank you, CJ. Good morning, Justice DJ Ledwaba.
Good morning, Commissioner.
I just have two questions from my side. The first one relates to how do you understand the role of a judge president in safeguarding judicial independence while ensuring that effective court administration is guaranteed. I think this is important because our appreciation of judicial independence is that it is the ability to decide cases on the basis of established law and merits without substantial interference from other interests, whether it's political, whether it is executive or criminal syndicates. The second one is, if you are appointed as Judge President, what systems will you put in place to ensure that we protect the reputational risk of the division from case allocation, on case allocation? Thank you.
On the first question, the role of the Judge President, as a Judge President, you are the leader. And for you to be able to lead the judges properly, it's important to have an open door policy and to have interaction with your judges. So I've served under retired Judge President Mwepe. I've learned a lot from him about his leadership. I've served under the DCJ for more than 10 years. I've also learned a lot from him. And what I can say is that I just need to improve and ensure that we as a judiciary, we work together. And on your second question, if you don't mind, if you can just repeat it, I've missed it.
Thank you, DJP. The question is, what systems are you going to put in place as a Judge President to prevent reputational risks arising from case allocations? Thank you.
To avoid reputational risk of the judges is that the judges need to understand that we are there as judges to serve our people. We are there as judges to ensure that judgments are delivered on time, and if there are aspects or maybe there are challenges that are faced by the judges, we ensure that they are dealt with effectively. And to always remind your judges that they should not forget the oath that they are taking, that they are going to serve without any fear or any prejudice, and to ensure that the Constitution as a supreme law is respected. Thank you.
Thank you, DJP. Thank you, CJ.
It is on.
Thank you, Chief Justice. Good afternoon,
Good afternoon, Deputy President.
DJP Ledwaba. Now, I've got just three questions for you. The first one relates to the bail matter that you handled. That you were not sitting there as a court of first instance, but it was an appeal from the magistrate decision to refuse to grant bail. Is that correct?
DP, which matter are you referring to? The one where I granted bail?
Yes, the allegation that something that should not have happened, or there was a suspicion that something might have happened.
Yes.
But that matter, when you dealt with that matter, you were dealing with it not as a court of first instance, but it was an appeal against the magistrate decision to refuse to grant bail. Is that correct?
That's correct, DP.
And you dealt with it in accordance with the established principles of criminal procedure relating to the grant of bail. Is that correct?
That's correct, DP.
All right. Then you were asked by the Chief Justice just to give us an outline of what your vision is relating to the Gauteng division of the High Court. And one of the things that you mentioned, you said that you need to maintain the high standard that had been established. And then you do that by making sure that suitable people or judges are appointed or acting judges are appointed. Is that correct?
That's correct, DP.
What about the sexual harassment complaint? Because that should also be part and parcel of your vision, so that the people that you recommend for appointment, you will make sure that are the people that are not going to be involved in such practices, and if they do, there is a mechanism in place to deal with such complaints. Can you just assist us there when it comes to the implementation of the sexual harassment policy?
In respect of the sexual harassment policy, I'm glad that the policy is now in place. And I'm also in the committee that ensures that that policy is understood and there's no sexual harassment, and you are chairing that committee. Because of things that have happened before, DP, I think that policy is a good policy that would also ensure that no one would take advantage of their staff, no one would take advantage of other colleagues. So in the committee that has been appointed, at the moment, what is going to be implemented is a training of judges in respect of that policy, which I think is a good thing that Sajay is doing. But with what we read out about the sexual harassment, DP, I think this policy will have a strong deterrent effect on those who potentially think that they could take advantage of women.
Thank you. And my last question to you relates to what extent can the judiciary assist in eliminating or preventing the Stalingrad tactics? I was happy with your answer, but at the same time, I think that the question should not only be confined to the judiciary. There is this section in Section 17(2)(f) of the Superior Court Act, which allows an aggrieved person or litigant whose petition for leave to appeal has been refused by 2 judges to apply to the President of the Supreme Court of Appeals for reconsideration. And we have been inundated with a number of Section 17(2)(f) application, and they've taken a large part of our role. And so some litigants are using 17(2)(f) as a tactic to delay the finalization of the cases. So in other words, it's not only the judiciary that should strive to make sure that the Stalingrad tactics are eliminated, but maybe to a certain extent, the legislature should reconsider the Section 17(2)(f) provisions, which allow litigants a litigant to feel aggrieved by the refusal of petition to approach the President of the SCA to have his application for leave to appeal reconsidered, to give that, because they're using that mechanism as a second bite at the cherry. So what is your comment on Section 17(2)(f) in particular? Thank you.
Deputy President, my straightforward answer is that I think the legislation needs to be changed, because these petitions are dealt with by 2 judges. And now, in terms of the section, it says that now the President should look at whether the other 2 judges' decision is proper or not. And I think to a certain extent, if maybe there could be a situation in terms whereof when the 2 judges have looked at the matter and they don't agree, then the 3rd judge should be added. But the way it is at the moment, a short answer, DP, is that I think that legislation needs to be changed, because that matter would have had the attention of 2 judges.
Perhaps I should add, DP, that I made full representations as head of the SCA to the Department of Justice. That was during the tenure of Minister Masuta. That tells us how long ago that was. just pleading for the repeal, or at the very least, the amendment of that section, those provisions, which cause a nightmare. They cause a lot of work first for the president of the court. There was a time when I was just dealing with 17 2F applications and not able to do my other work. And the other, the other reasons given by TP Zondi. And we've not heard that there's been any progress, Minister, and I'm asking you now, in front of the nation, to please assist us, please assist that court, please assist the judiciary in this regard, and chase the legislature to do the right thing. Please, TP. Okay.
Thank you very much, CK. Thank you. Thank you, DJP.
Thank you, DP.
JP Tlalezi.
Thank you, Chief Justice, and good morning, AJP Ledwaba.
Good morning, JP.
Firstly, just to emphasize that we do not have control of what is said in the media. Where I'm seated, I'm being showered with praises for my great achievement. I have been sent an article which appears to have been on the business day. And it reads thus: the Judicial Service Commission, in brackets JSC, has recommended 3 judges, Noma Tamsanga Nomisa Nomen, Pule Tlalezi, in brackets Vali, and a 3rd candidate for appointment to the Supreme Court of Appeal, SCA, in brackets, following April 2026 interviews. These recommendations are now forwarded to President Cyril Ramaphosa, who holds the authority to make the final appointment. So we do not have control as to what is happening in the media.
Noted, JP.
Yes. Now, my question, someone will say, relates to ready to govern, but not in that sense. You have been the chairperson of the Chief Magistrates, of the Magistrates Commission. Can you tell us about your readiness to take leadership of the division? Your involvement in the Heads of Court Forum and the subcommittees related thereto.
JP, I'm ready to lead the division. And one of the commissioners at the Magistrates Court said to me, should you be appointed, please don't resign as a chairperson of the commission. And I must also just confess that there's a lot of work that needs to be done at the Magistrates Commission, and there's a lot of work that needs to be done as if I'm recommended to be the head of the court. I believe that should I be recommended for the position of the JP, the workload may be too much, and it may also affect me in leading the division. And this is an aspect that I'll have to discuss with the minister to see how can the work be shared, because the meetings of the Match Commission, they are held every quarter, and they will take about 2 or 3 days. And almost every 2 weeks, one needs to attend meetings of EXCO. And also there are important things that need to be done as head of the court. So my answer is, I think the work will be too heavy. And maybe one will have to reflect properly on whether should I still continue to be the chairperson of the commission. I hope I've responded to your question.
Yeah. But then being the AJP and the chairperson of the commission has exposed you to be part of the heads of court forum.
I beg your pardon, JP?
Yeah, you're being chairperson of the Magistrates Commission and being the AJP has exposed you to be a member of the heads of court.
Yes.
Yes. What exposure have you gained? What experience have you gained that will assist you to lead the division?
Yeah. The exposure that I've gained is that there are important issues that are discussed at the meetings of the heads of courts. And fortunately, the CJ, in her wisdom, has now introduced a system in terms whereof heads of courts in the magistracy are consulted and there are issues that are discussed with them. So I've learned that being part of the heads of the courts, it's a more important task that one needs to do. And since heads of the magistracy now would be having regular meetings with the Chief Justice and other heads of courts, this in a way may reduce the workload of the chairperson of the Magistrates Commission.
The committees of the heads of court in which you are participating?
At the moment, I'm participating in 2 committees on the Sexual Harassment Committee. I'm also in a committee led by JP Poyozwati, wherein we discussing the issue of robing of advocates in the lower courts and also robing of magistrates, that magistrates should also be properly robed when they sit in their courts.
Have you played any role in the PECs, Provincial Efficiency Enhancement Committees?
Yes, JP. I used to attend those meetings with the DCJ. We had our PEC meeting sometime about 3 weeks ago. But what I intend doing, JP, is that I think it would be more beneficial if the Deputy Judge President is also part of that meeting, because important things are discussed, and should it happen that the meeting of the PEC clashes with some other important meetings of the heads of courts, there should be continuity. And introducing both DJPs, I think it would improve the workings between what the PEC is doing, because after that meeting, there are also some other things when you look at the action log that needs to be done. And when you delegate those responsibility to a DJP who's been in that meeting, it would make the job easier.
I think that's one of the best practices that you can learn from the Northern Cape, that the DJP is always involved in these committees at all times. And the second issue, I think Commissioner Muima may ask you, but I understood it differently from you, about how could you protect the integrity of case allocation. In my division, allocation of cases is centralized. In the JP's office, in his absence, the DJP. That might not be possible maybe in the division in which you are to lead if appointed because of the number of judges there. So maybe some allocations may be made by senior judges or whatever. Now, what system is there at the moment and how maybe we could improve it to ensure that there's no forum shopping, judges don't exchange files, you might not know the reason why they exchange those files.
JP, as a leader, you need to know your judges. You know that there are judges who take time to produce the judgments, and there are certain urgent matters wherein you find that after those matters shall have been heard, the judgments need to be produced within a matter of some few days. So, allocation, as I've also done as an acting JP, is that in certain instances, I would consult with the acting DJP to say, we've got a matter of this nature. I've got these judges in mind, and their input are also valuable. But at the end of the day, as a leader, you really need to know your judges, their strengths, and those who still would need more time to do judgments, you ensure that they're given more time to write judgments in respect of those matters. But knowing your judges, it's the best way that can assist you in allocation. And also just to make it very clear to the judges that if a matter is allocated to you, there's no way that you'd give it to another judge without consulting with the leadership.
Don't you have a problem where senior judges will allocate all the work to junior judges and have got nothing to do themselves? And if that is a problem, how do you deal with it?
JP, we have experienced that problem. We've discussed it at our meeting. Now, what I'm doing, especially with opposed motions, because you find that we'll be having about 50 opposed motions to be dealt with by 10 judges. In the urgent court, now we have introduced a system where we've got, we are putting 3 judges. So the week before those matters are heard, the judges would send a report to me indicating which matter has been given to other judges, the duration of those matters. That helps to manage the process very well, because there were complaints by some junior judges that, especially with opposed motions, some of the senior judges would deal with matters wherein they know that there would be settlements, and you find that in that week on a Tuesday, that senior judge is done with his or her matters. And the other thing that we have introduced in Gauteng is that the senior judge should always engage with the other 4 judges to check if they cannot assist each other, because in certain matters they don't settle, and you find that another judge has got more work, so that if another judge's matters have been settled, he or she can assist other colleagues. So that is done on a weekly basis so that I can be sure that the allocations are fair, allocations from the senior judges.
And then your ability to take decisions. Are you a populist, or are you the kind of leader that will take decisions and ensure that they are implemented and there's consequence management if that thing is being done?
As a leader, one must just take those decisions. And if maybe one of your colleagues think that the decision that you've taken, you give that colleague an opportunity. And in most instances, as the DCJ used to do, would call the DJP to discuss those matters with him. We had a matter wherein a junior judge did not want to write a judgment of a full court. And we called all the judges And the solution, we told all of them that each judge should write his or her judgment. And amazingly, after about a week, after each judge wrote the judgment, and they all agreed and the judgment was delivered. So there are certain decisions that as a leader, one needs to implement.
There's a growing trend now in the judiciary for.
It is 3 questions, JP. I don't like pulling up my dear colleagues.
No, thank you.
Even if they're asking relevant questions,
Thank you,
but
I'll
due
end
to time
there, CJ.
issues,
No, thank you.
ask you. Thank you, JP. Commissioner Matolo Lebo.
Thank you, CJ. And good morning, Acting Judge President.
Good morning, Commissioner.
How are you?
I'm good.
Thank you. In your vision, you mentioned that you're going to be elevating women judges.
Yes.
In your division. I really applaud you for that. But one of the things that I want you to think about is the question of the criteria for appointing acting judges. Because from the constituency that I come from, women organizations, they just feel it's so unclear how acting judges are being appointed. I know that there was a policy criteria that was circulated, but it hasn't been finalized. I think for us, it will really make a difference to know that for a person to want to be an acting judge, this is the criteria. That's one thing. So that you avoid people who you think you don't qualify to be acting judges. So if there is a criteria, definitely it will help from yourselves. As the JPs, I know that there are a lot of JPs in there, even JP Kalez. So the criteria for us as the practitioners, especially women practitioners, is very important. It needs to come out and to be discussed. Thank you. I know that the profession has given its input, but so far nothing has come out. The second one for me, that was my comment only. The second one, I know that we to deal with the workload, we've introduced mediation. What I just wanted to know, because is there any statistics that shows how successful this mediation is, and how do practitioners really follow it, do it, or do they do it for the sake of doing it? Because my problem is that aren't we extending or making sure, delaying the finalization of matters? I just want to hear your view from there. That's my only 2 questions.
Thank you, Commissioner. On the issue of appointing acting judges, I mentioned that I sit with top senior judges from each division to get their inputs and also for them to make recommendations, because these are the judges in most instances who are in court, and they can see how the practitioners are faring in court. And the other advantage is that acting judges who have been appointed, they've got the benefit of sitting with them in full courts, discussing other matters with them. So it's really a valuable tool that we are using, because I can also indicate that I get a lot of applications by practitioners who says that I should appoint them as acting judge. And it has not been, this is not the practice of how the judiciary works. You don't apply to be appointed. You've got to be recommended by your colleagues. And I also contact the professional bodies to make recommendations, and that is also helping a lot. On the issue of the stats, we do get a report, I think it's every 2 months, maybe Judge Davis can just confirm this or not, which indicate how many matters have gone for mediation. But I need to mention that the big problem with this mediation thing is that there is a party that does not cooperate. To an extent that the directive states that if another party does not want to cooperate, you must go to court and get an order that the matter should proceed without mediation being held or the parties to be exempted from that. And it's really disturbing to say that at the moment, the role of the SIC has increased. We've got about 16,000 applications to the SIC that we need to deal with. And we had a discussion about how do we resolve this. But if the RAF can cooperate, this would not be a problem. But because there's no cooperation, then the role of Special Interlocutory Court has increased. It is something that we are dealing with, and we've made a commitment that we want to ensure that by the end of this year, with the extra judges that we've got, we need to resolve this issue. And this issue, again, because now if these matters are from the SIC, they increase the number of default judgments, but we are on it. During recess, there are judges who are sitting there doing the work on pro bono basis. We don't have enough courtrooms. The judges that are dealing with the SIC and the default judgments, they deal with these matters virtually. Thank you.
Thank you. I just want to appeal that I do understand how you appoint acting judges, but I think if it's written somewhere, it will be better for people to understand, because what you practice in Gauteng is not the same like anywhere, maybe in Northwest or, I think it will be a good thing for us, everybody to understand that senior judges sit and recommend, but if nobody knows that, it becomes a problem. Thank you.
Yes, I take your point, and as I said, the recommendations from the professional bodies like NADEL, JSC, Johannesburg Society of Advocates, and also Pretoria Advocates. We've also written letters to organizations like PABASA that they should recommend people and also ensure that the people that they are recommending, there are no pending cases or inquiries against them. Because recently there is an acting judge that I had to ask the minister to revoke it because that acting judge had a pending matter in the Johannesburg court. Thank you.
Thank you, Commissioner. Commissioner Janimhang.
Thank you, CJ. Still morning. Good morning, AJP.
Good morning, Commissioner.
My first question. Judge President Mlambo, as he then was, placed a considerable emphasis on the relationship or on building the relationship with the academic community, including and visiting the law faculties to encourage academics to consider acting appointments at the High Court. So my question is, in your view, is there value in strengthening the bridge between the judiciary and the academy? If so, what principles should guide such engagement?
Commissioner, there is real value in interacting with the academics. And from what the DCJ introduced, when in each term, I make sure that I get one of the academics to come and act in the division, because the academics play a very important role. There are certain things that we learn from them, and this practice of always ensuring that they are part of the acting judges is something that I intend continuing with.
Thank you, AJP. And then my next question is, what is your leadership philosophy, including your leadership style? And in answering that question, what characteristics do you have to make you suitable to be the JP of the Gauteng province?
My leadership style is to have an open door policy and to encourage the colleagues that they can contact me anytime, even if it's during the weekend, so that we can deal with the issues that are there. And it's important that even if maybe one gets a complaint from members of the public, that you invite your judge to discuss with them, because it's very important that you should have all the versions of the other parties. But leading on the philosophy of having an open door policy, I think that is what works. And on the second question that you raised, if you don't mind, Commissioner, can you please just raise it again so that I can answer properly?
Certainly. What characteristics do you have to make you suitable to be the JP at Gauteng?
Well, it's a difficult question, but I think the fact that my colleagues cooperate with me, they raise issues with me, it's an indication that I'm always willing to listen to them and understand the challenges that they are facing.
Thank you. Thank you, CJ.
CJ, may I bring in a follow-up, please? Good morning, Acting Judge President.
Good morning, Commissioner.
As you would have read in the GCB's review, they also inquire about how you intend to lead the division and whether, in particular, you would sit in high-profile cases and give jurisprudential leadership. What would you say to their query?
Excuse me, what would I say to the?
Would you sit in the high-profile cases that came into your division? Would you consider it as part of your leadership to give jurisprudential leadership?
Definitely, yes. There are those cases that would need a leader of the division to be part thereof. And it has always been a practice in the high courts that the cases involving especially the leaders of the country needs to be dealt with by the leader. And as you would have been aware, is that in such high-profile matter, almost in all of them would set a bench of 3 judges to sit in those matters. So it's very important that as a leader of the court, one should sit in such matters. Especially there are other matters that would also involve judges to ensure that you get judges from other divisions. But as a leader of the court, you need to be seen to be engaging in other matters.
So may I presume then that you would allocate cases for yourself to hear that actually had important matters of principle or were high-profile cases involved, so that your resources were devoted to matters of some importance?
Yes, I'll definitely allocate those matters to myself.
In relation to the bail application that has landed you in some trouble, Mr. Molefi's application, was there any particular special circumstance that would have motivated such a senior person as you to personally deal with that matter? And I raise it because I would imagine, for example, that you wouldn't sit in run-of-the-mill cases that ordinarily come to the court in great volumes, divorce cases, RAF cases, bail applications, even on appeal, unless there was some special circumstance that caused you to hear that.
What made me to hear the matter, it was not because of the matter involved Mr. Molefi. It was during recess. And there were bail applications that were to be heard, and it was a long recess. Now, to wait for the next term to start and to allocate matters, I was of the view that those matters involve the freedom of the people. And as I've said, I've dealt with 2 matters in that period. And mainly because they are urgent and it involved freedom of the other people and there were no judges available to do it. If there were judges, I would have definitely allocated those matters. In most instances, I do allocate these matters to judges who are mostly doing criminal work. And those judges were also involved in other apartheid matters. And as I've said, as a leader, I also need to be seen to be involved in other matters, not only high-profile matters. It helps as a head of the court to go to what could be regarded as maybe to do the unopposed. It's important to go there. You are in a position to can evaluate the workload, how many matters need to be allocated to judges. Because there are certain instances where other judges would say 20 matters on the unopposed would be enough, and there are other judges who would say, give us 50 matters. But if one has practically dealt with those matters, you've got a good sense of what is happening in that court, and you can make a decision as to how many matters should be allocated to each judge.
Thank you. I accept your answer. Thank you, Chief Justice.
Commissioner Mangen?
I wanted to make a follow-up.
To Commissioner King's...
Yes.
Okay.
All
right. And the professor?
Yes, the prof. Acting JP, the question was, if you were to assume that responsibility, what do you bring with you? Because it's a position of responsibility. And the answer that says, well, I'm a DJP, an acting JP and chairperson of magistracy. I've played that leadership role before, and therefore I come with that kind of experience to this particular responsibility. Will that not be sufficient?
I think that's sufficient.
And then, is there any rule that says, as a JP or acting JP, there are certain matters you can't hear, including bail?
There's no such a rule.
Thank you.
Commissioner. Thank you.
Your turn.
Thank you. Good morning, AJP.
Good morning, Commissioner Mangena.
I would love to converse with you just on this aspect, but looking at the optics of the matter. Not so much about what actually happened. Earlier on, you were asked by Commissioner Ngwedobi if you accept that the allegations made at the Madlanga Commission were serious. And I did not hear your answer, whether you accept that they are serious or they are not serious. Now, I need to ask you, do you consider the allegations made there serious?
Commissioner, those unsubstantiated allegations, in my view, they cannot be regarded as being serious. I've also mentioned that there's a criminal case that has been opened at Boschkop. But when you look at what is said, it's just an allegation that these judges received money. Nothing substantiating it. And because there's no substantiation, I take them not to be serious.
But then why did you want to respond to them? If they were not serious, why did you want to respond to them at the Madlanga Commission?
I wanted to respond to them because my name was mentioned. And I also indicated in the letter that we wrote to the commission that if these allegations are serious, the matter should be reported to the relevant body.
The Office of the Chief Justice issued a media statement acknowledging that the testimony or the allegations are unsubstantiated, but they've got the potential to damage the integrity of the judiciary. Do you accept that?
Yes, I do accept they've got that potential, but in deciding how to deal with those allegations, one also needs to look at the integrity of the judiciary, and hence I've said these are difficult things that are there. I made it a point that I consult with senior judges and other retired judges to get their view on it.
Yes, and that's an issue for me. The Office of Chief Justice suggests to you that you consider taking special leave. You don't, you decline, and then you go and solicit advice from retired judges. Between the Chief Justice and the retired judges, who is the custodian of the integrity of the judiciary?
It's obvious, it's the Chief Justice who's the head of the judiciary.
And then why did you choose to ignore the suggestion and advice coming from her? She was not saying that you're guilty.
Yes.
She was not saying that you took the money. She was only saying that it will be in the best interest of the judiciary if you take this course of action.
I think the candidate has answered this question, Commissioner Mangena. In one context or the other, he has given his answer, and I would ask you to leave it.
Well, I'll accept your guidance.
Thank you, appreciate it.
I'm done, Chief Justice.
All right. Thank you, Commissioner Mangena. Perhaps I should follow up, Deputy Judge President. No, I've not forgotten you. This issue was raised by the Objections Committee at the outset. Commissioner Trollip raised it with you, and now Commissioner Mangena. And I'm raising it again because it's going to be a big issue at deliberations later, I can assure you of that. And I want to give you a chance to give you your very best answer. You have been a DJP of that big division since 2013. It's been 13 years now. When former Judge President Mlambo became Deputy Chief Justice, you seamlessly stepped into the role of acting Judge President to hold the fort until a permanent appointment is made. And all indications are that you're steering the ship, excellently, if I may say so. There's no sign at all that the division is in distress. Its affairs are in limbo because there is no permanent JP yet. Now, importantly, there is no other contender in sight for this position. You seem to be the solo horse. Now, in the face of this background, especially the objections raised by bodies such as the the Helen Suzman Foundation and others, and all the chatter that is taking place in the public spaces about this issue and what has been happening within the judiciary in recent times, the shocking allegations and everything else, imputing negativity on the integrity of the judiciary. A lot of people are asking, and it will be asked at deliberations, as I said, why we cannot wait until the Madlanga Commission has cleared you, or at least the matter has been put to rest, has been brought to finality. Or we don't know that there is an interim report which has not been made public. Maybe the president will make it public one of these days, and we may get to know what findings were made by that body. Your candidature, I think this is the elephant in the room. Your candidature is shrouded in this dark cloud, which you don't deserve. I mean, you're a good leader. I've worked with you for a long time. I've served as a judge with you. So your appointment should not be shrouded in negative chit-chat. And the judiciary, it may be said, does not deserve that. Why should we not wait while you act in the position? And that is the question that will be asked at deliberations, I can assure you. What would you say for yourself?
Chief Justice, my answer to it is that the Gauteng division needs to have a leader, not necessarily myself. And it will be in the interest of the judiciary that there should be certainty about who is to lead this division. Personally, I'm not saying it should be done now, but considering all the other factors that this cloud that is hanging was conveyed to the Commission, and the Commission, in their letter that I've got here, they said they will ensure that there's no prejudice, they'll deal with it before today. There has been other clouds, as I've mentioned, that were made. And to say that all these allegations need to be cleared first, the criminal case that has been laid and the summons that I've mentioned that they are suing me for 50 million, I don't think that is in the interest of justice. So that's my answer to the question that you raised.
Thank you, DJ.
Thank you, Chief Justice.
Commissioner Lukhanyana?
Thank you so much, Chief Justice. I thought your question will be the last. Is it still morning? Good morning, Matawel.
Good morning, Scholar Sarale. We'll have just some few minutes before it's 12.
Le sing a follow. The latest information or rumors that I heard is that Gauteng may be the largest or among the largest provincial divisions in the country. Is that correct?
That's correct, Commissioner.
And one of my fellow commissioners here has asked you about one of the legacy projects that were left by your predecessor, Justice Mlambo. And amongst them was the use of technology and many other avenues that would be available, like virtual courts that he has initiated. And when you were given a chance here to give us your vision, I did not hear you espousing that. What is your comment on that?
What DCJ has introduced is working very smooth. And it's just a question of improving it where it's necessary. For instance, having a strong Wi-Fi, but will definitely ensure that as it is spread to other courts, being the court where the system started, will definitely improve on it and continue with it.
So, that is very fundamental to access of justice in the country. Given the context where we come from, the context of dehumanization, exclusion, marginalization, and that access to justice has become very onerous, given population growth and other constraints that we may have as a country. It would be very important that if there are challenges, you could share with us what are the successes, what are the bottlenecks that are there, and what do you suggest are the interventions that can be made? Or if there are good practices, how do we keep that going?
The challenges that we have experienced is in respect of other members of our community who don't have the laptops and other things, but provision has been made that they can come to court where they would be assisted in utilizing the facility. And the other challenge is that there are instances where there are challenges with connection and that is attended to. But those challenges are not challenges that cannot be dealt with. And we are also consulting or contacting the committee that has been put to deal with the virtual hearings and so on. So it's something that is also discussed at the heads of courts to see to it that this process move forward, because it's convenient for everybody. Thank you.
So do we have your commitment that the modernization project is on track and you will continue to champion it?
Yes, Commissioner, is on track, and they will definitely continue with it. In both divisions, there's also a special committee that looks on the challenges, and they make a report at the end of each term to other judges about the modernization project. Thank you.
Thank you so much. Chief Justice.
You've finished? Oh, thank you, Commissioner.
Follow up. CJ.
Commissioner Ngoitok?
Yes, Chief Justice. I just wanted to follow up not on Commissioner Lekhanya's question, but on your question. DJP, do I understand that you asked the Madlanga Commission to finalize your matter prior to this interview?
I did not ask them to finalize it. We indicated to the commission that I have applied, and then they should look into it. And in their response, there's an undertaking that they made that they will finalize this issue before the interviews.
And do you have that response in writing? That's really what I'm interested in.
I've got it in writing.
Yes.
And I can try to check the letter and quote exactly what they said. I would need my glasses now.
Take your time.
The response from the commissioner's attorneys in their letter of the 12th of November, it states as follows in paragraph 4, I quote, "Through this report, the commission will attempt to ensure that your client is not unfairly prejudiced by unsubstantiated allegations made against him in the commission."
And to assist JP, I'm just interested in the portion where they say this matter will be attended to before your interview.
Okay, yes, I'm trying to check that. In their letter of the 12th of November, the response is that the commission, I quote, "will be issuing an interim report in December 2025 and barring unforeseen delays, hopes to be able to issue its final report before the Judicial Service Commission hearing are held from 13 to 17 April 2026.
Yes, thank you. And you've had nothing since?
I've had nothing since.
Thank you.
Thank you.
Follow up, CJ.
Yes, Commissioner.
Judge Ledwaba, there was also an ad hoc committee established by Parliament to investigate allegations that were made by Lieutenant General Mkhwanazi on the capture of the criminal justice system. Have you ever been called by the ad hoc committee to answer those kind of questions?
I've never been contacted or called in respect of these allegations, Commissioner.
And are you aware that that committee has finalized its work?
I'm not aware, Commissioner.
So you have never been, or you writing to them and saying there were these allegations made somewhere else, but it looks like you're equally investigating almost similar issues. If you are interested, I'm available to come and make my case before that committee.
I haven't contacted the committee, Commissioner. We only contacted the Madlanga Commission because the allegations were made in the hearing that they are chairing.
But if these issues were so serious, do you think that committee was going to miss you? Because amongst other things, it was investigating corrupt police, prosecutors, and judges. If those allegations were made at Madlanga and the committee hears of such serious allegations, do you think they would have missed an opportunity to call you to come and explain at the committee if the allegations were serious?
I think on what was said there, they deemed it fit not to contact me about those allegations.
Thank you.
Thank you.
Any further questions for the candidate? We've reached the end of your interview, Deputy Judge President Ledwaba. Thank you so much for your patience. It's been a long, long morning.
I thank you, Chief Justice, and the commissioners, the way in which they asked their questions. They were fair questions. No question was intimidating. And except
we don't set out to intimidate candidates, JP.
Except to say that JP Tlaleti has been congratulated for going to the SCA. Thank you, Commissioner.
Go well. Thank you. Shall we have the room cleared, please, so that we can go to deliberations?